Hi, welcome to the Network for Law Students LLC. I'm Randy, and I graduated from law school in May 2019 from the 2-year accelerated honors program at my school. I'm doing this video because I just want to help somebody, somewhere, somehow during this crazy COVID virus situation. I have the privilege, and it's weird to call it a privilege now because it certainly did not feel that way at the time, of taking remote exams in the hospital due to an injury I suffered during my first semester of law school back in 2017. I'm fine now, but I remember how it was, and for many of you, you'll be taking remote exams for the very first time during this pandemic, in addition to your classes. I'll be giving advice that are both for remote exams and for regular in-person exams. I know graduations have been canceled due to the virus, and I know you're disappointed. I know that even those that are not graduating right now this year have missed out on some opportunities. I know you're upset. Go ahead and feel those feelings. While, yes, it may not be as serious as what everything that's going on with the virus, but don't shame yourself from feeling sad about it. You did lose something. You lost yourself to normalcy. And this is all due to the selfish and uneducated decisions made on the individual level by some of our government officials and in governments worldwide, not of your own making. So feel those feelings. It's okay. Don't beat yourself up for feeling bad about something that even though other people have gone through more serious things. I can't imagine how it's getting to you emotionally when you're already stressed out from law school. Let me just tell you, I went through a lot in law school myself. Some objectively unfair things that were not of my own making. But each time I took the unfairness of the situation and I let it fuel me. And I hope this fuels you. The Leitner system with spaced repetition. Think of a filing cabinet. In order to put anything else in that cabinet, some maintenance is required, but over time, as life gets in the way and maintaining that filing cabinet is not as important, or even if it remains a priority, there's only so much cleaning you can do when more and more items need to be put away in that filing cabinet. According to Benedict Carey in his book, How We Learn, some breakdown must occur for us to strengthen learning when we revisit the material. Without a little forgetting, you get no benefit from further study. It is what allows learning to build like an exercised muscle. So enough of the background for now. Let's get into the recommended time intervals between study sessions. Well, you can't study forever, right? So the best spaced repetition time interval depends on when the exam is scheduled. Benedict Carey, in his book How We Learn, created the following time intervals: 1 week, 1 to 2 days, 1 month, 1 week, 3 months, 2 weeks, and also 6 months, 3 weeks, 1 year, 1 month. Let me interpret the first interval so you can get a sense of it. Here, it's saying that if your test is in a week, and let's say today is Monday, you should study the card today and then again on Tuesday or Wednesday of this week. As with anything, you're not stuck with this. Do what's right for you and choose your own study intervals. The spaced repetition system and the Leitner system fit together nicely. Let me give you a little background to the Leitner system. The Leitner system was created in the 1970s by Sebastian Leitner, who was a German scientist and journalist. The Leitner system is a system of graduation using flashcards, where the graduation to the next level is based upon whether you correctly answered a card. Should you get the card wrong, it remains on that level that is oftentimes referred to as a box. Since the system works with spaced repetition time intervals, considering the date the exam is scheduled, pick the intervals that will work for you and assign them to a box number. For those of you not familiar with what a flashcard is, flashcards are a paper tool that is used for learning, internalizing, or memorizing, where one side of the card represents a question and the response to that question is on the back of the card. The spaced repetition system and the Leitner system fit together nicely. The spaced time intervals that I chose for myself before I graduated law school look something like this. Box 1 was every other day. Box 2 was every 2 to 3 days. Box 3 was once a week. Box 4 was once every 2 weeks. I also had a fifth box, which I used to call the check box, that I would review the cards 2 days before, the day before, and the day of the exam. After you set up your boxes, just set reminders in your computer or phone's calendar, or set up a manual tickler system. What's a tickler system? A tickler system is a series of reminders to do something. For example, when I was working as a litigation paralegal, I'd have reminders in Outlook as well as a manual tickler system, just in case my Outlook email account could not be accessed. For example, if I sent a discovery request to opposing counsel for an authorization to obtain medical records today, then I'd set a reminder for myself to follow up in, let's say, 2 weeks, then another reminder for a few days after that, and then another for a week later. Spaced repetition combined with the Leitner system is a more efficient way to study since you're not using time on concepts that you already know really well. So let's say I was studying battery in my torts class. On one side of the index card, I'd put, what is a battery? On the other side of the index card, I'd put the correct answer to the question, according to my torts professor, which was an intentional, harmful, or offensive touching without consent. If I got the right answer, then I would keep graduating the card. So if after the first study session I answered correctly, I'd move the card from box 1 to box 2. In the 2 to 3 days when it was time to study again, I'd take that card out again and see if I got the correct response. If I did, then I would move the card from box 2 to box 3, so on and so forth. Each time I got it right, I would increase the time interval in which I need to study that information again. So again, this is what it would look like if I got the answer right. But what if I got the answer wrong? What if instead I said the answer to what is battery is it's the breaking and entering of a dwelling house of another at night with the intent to commit a felony therein? That would be an okay definition for common law burglary, but wrong for the question on what is a battery. So what would happen then? If I responded incorrectly, then it would either stay in box 1 or return to box 1 if I answered incorrectly even after advancing it to the other levels in previous study sessions. Just a quick note. I don't think you actually need boxes. Other things would suffice, like using rubber bands or putting it in different areas around your home. To that end, my opinion is that you don't need index cards to do this technique. There are also apps available. There are spaced repetition apps for your phone and your computer. Anki is one example. It's customizable. You can rate the level of difficulty you had in recalling the other side of the flashcard. If you get it wrong, it will come up again in the same study period until you get it correct. Correct answers won't show up as frequently. This is great because then you won't spend time studying concepts that come easily to you. Here, I've listed other apps for you as well. Thank you for listening. Don't forget to like, subscribe, and share our YouTube channel. Hit that bell so that you'll be notified whenever we upload a video. We're also on Instagram under Networking for Law Students 1, and we are on Facebook at Networking for Law Students. And be sure to visit our website, which is networkingforlawstudents.com. Active recall. You probably heard of the child's game hide and go seek. Well, I like to call this technique hide and let's get it. Active recall is a study technique that involves engaging one's memory more dynamically than passively watching a video or rereading or repeatedly reciting the material that you're studying. It involves quizzing yourself on the concepts right after reviewing them to better reinforce them in your mind. In law school, that can be done through getting a professor's old exam that tests the concept and practicing one, or practicing using a supplement, using a bar review program like Adapt-A-Bar. Or it can be done by coming up with your own basic questions. If you don't know the answer to the question, we'll hide and let's get it by looking it up in your outline or notes or casebook. The process of looking it up could help you to remember it. To come up with your own questions, pretend you are a junior high school teacher. Based upon what you just read, go by line, what short answer questions could you come up with to quiz your students? So let's practice this together. Let's read the following from my constitutional law class. Before I read it to you, please note that while this is from my actual law school outline, this may not be correct, or it may not be something that your professor wants you to focus on. So please don't copy it into your outline or into your exam response. The examples that I give throughout this video are just for the purposes of demonstrating the technique. So let's read it. The Equal Protection Clause from Section 1, Clause 4 of the 14th Amendment awards equal protection of laws to any person, not just citizens, within the state's jurisdiction. The classifications that typically pose a problem include laws that treat similarly situated people differently, laws that treat people differently based on their race, laws that harm discrete and insular minorities, and laws that are arbitrary and irrational. Based upon what we just read, pretending you're a junior high school teacher and you're giving those preteens a pop quiz, what's one question that you could ask them? I'll give you 20 seconds, starting now. These are some of the questions that I came up with. In which amendment does the Equal Protection Clause appear? To whom does the Equal Protection Clause apply? What are some classifications of the laws to which the equal protection would apply? Which government does the Equal Protection Clause apply to? Let's try another one together. The courts afford the legislature a presumption of constitutionality under both the Equal Protection Clause or the Due Process Clause, Section 1, Clause 3, which provides that no state shall deprive any person of life, liberty, or property without due process of law. Again, pretending you're a junior high school teacher giving your students a pop quiz, what short answer questions would you have for your students based on what we just read? I'll give you 20 seconds, starting now. Here are the questions that I came up with. With respect to the legislature, what will the courts do with the laws at issue? What's the presumption from what to what? What is the Due Process Clause, and how is it different from the Equal Protection Clause? If at all, how does the presumption relate to the Due Process Clause? Then redo these questions one by one each time you study. Can you fully answer these questions out loud? Then later on, a few days from now, see spaced repetition. Repeat the questions. Maybe color code wrong answers per session. The Notion app is particularly useful for the active recall studying technique
because it allows you to enter your study material, the questions you made up, and then a toggle drop-down menu, should you choose to do so, where you can include the answer to the questions. If you're watching this on Thinkific, don't forget to look at the short video for details. This is the end of the active recall portion of the video. Don't forget, Networking for Law Students LLC has merchandise, both apparel and accessories, available with different sayings to keep you encouraged. Exam day tips. First, a reminder to IRAC. IRAC in its various forms like CREAC or CRAC or CIRAC or CREA is a typical recommended format for constructing your essay response on an issue spotting law school essay exam. The acronym IRAC stands for Issue, Rule, Analysis or Application, and Conclusion. The issue is where you alert the person grading your exam to the topic or problem that needs to be addressed. The rule is a clear statement of the law, policy ground, or statute that governs the analysis that you are about to present to the professor. The application or analysis is where, in light of the relevant rule statement, you thoroughly but concisely evaluate the facts to resolve the identified issue. It's where you demonstrate to your professor how the facts will determine the outcome. The conclusion is where you clearly and concisely answer the question posed by the identified issue or issues. Remember, whenever there's a new issue and a new rule to be applied, you need another IRAC, not just one long one. So new rule, new IRAC. At the end of that portion of your essay, you should have a separate additional conclusion that is a statement form of the call of the question. In other words, when using IRAC or one of the other forms like CREAC, the overall conclusion should be directly responsive to the professor's call of the question. There should also be a conclusion to each issue that you spot in the fact pattern. There's no need to label with the words that make up the IRAC acronym. You don't need to say, "This is my analysis." Instead, there are words or phrases that you can use to signal to your professor the parts of the acronym that you are about to address. For the issue statement, you could use the words "at issue." For the rule statement, you could use the word "under." To signal to the professor that you are about to write your analysis, you could use the word "here." And to signify your conclusion, you could say "therefore," or "in sum," or the like. Miscellaneous exam day tips. Read the call of the question first. Knowing what to look for saves some time and effort. What subtopic of the course is the call of the question driving at? You'll have a better understanding of which facts are legally significant when you return to the beginning of the body of the fact pattern. Otherwise, you may waste time by focusing on the wrong thing. When you do go back to read the fact pattern, after each paragraph or after each sentence, ask yourself, what's the effect of what I just read? Only use the facts that you were given. Don't make up your own fact pattern just because that's what you know really well and wish that was what the exam was testing. While you do have to make a choice, talk about both sides. If the plaintiff was basing their argument on X, what would the defendant bring up to strengthen their argument in response? Then what would the plaintiff counter with, if anything? Whichever is a stronger argument, that's your conclusion. Please note that not all issues are created equal. There may be a major issue and several minor issues in an issue spotting exam, or several major issues and some minor issues on the exam. Discuss the minor issues, but leave the bulk of your time for the discussion of the major ones. In the fact pattern, make sure you focus on anything in quotes. Those things tend to indicate the state of mind, which is relevant in your criminal law, torts, and evidence classes. Also take notes of dates, distances, and amounts in the fact pattern. That information is probably pretty important to your analysis. Also take note of words that modify other words and adjectives and adverbs. Like if we were in contract law class and the fact pattern refers to written agreement as opposed to an oral agreement, or if it doesn't specify what agreement it is. If you were just reading that fast and missed the word written, you may waste a bunch of time talking about the statute of frauds as a major issue, when really, depending on the fact pattern, it would probably be a minor issue that you can mention and move on to a major issue, if any issue at all. Don't fall into what I like to call the Millennial Gen Z pothole. Please don't get offended by what I'm about to say, especially since I'm in that age range too, but millennials and Gen Zers alike have some stereotypes that professors may take advantage of in the fact pattern of exams. We have a stereotype of wanting the big bad corporate environmentally polluting giant to lose, and it may cause students to look at minor issues and treat them as major, or miss important issues in an issue spotting law school exam because they are trying to fit their argument over ensuring that the good guy wins. Don't get emotionally involved in these fact patterns. Sometimes the crappiest person or the crappiest company may have done things that are morally wrong, but it does not meet the standards to give rise to the cause of action that you are trying to make fit. Make the job of the grader easier by clearly labeling with bold writing, underlining, italicizing, using numbers or Roman numerals with headings for each part of the exam, each question, each new issue. I also recommend numbering elements of a rule. For example, instead of just saying battery is the intentional, harmful, or offensive touching of the person of another, I number it. So stating battery is the intentional, number 1 in parentheses, harmful, or number 2 in parentheses, offensive touching of the person of another. With everything clearly labeled, it will be easier for the professor or other grader to check points that you earned. Just like when we were reviewing what some buzzwords were for IRAC, instead of retyping or rewriting information that you already use in another part of the exam, you can use Latin words or phrases to direct the grader to another part of your exam. The word supra means that which went before or above. Infra means that which follows or below. Inter alia means among other things. On issue spotter essay exams, what I would do on the actual exam is first read the question prompt, then read the fact pattern once without taking any notes. Then I read the fact pattern again, this time taking notes as I read in the margin. Then on scrap paper or in any available space in the exam booklet, I'd create my mini outlines for each issue. Some people call it an issue T with 2 columns. I call mine an issue 3 because I create a quick 3-column chart. The first column would be a quick label of the rule of law. The middle column would be what facts in the fact pattern apply to that rule. And the third column would be what facts were missing or what facts of the opposing counsel could point to. As to the third column, for example, if it was a negligence question and there was no way to establish causation from the facts, I'd put the word causation there followed by a question mark. My setup for taking remote exams would look something like this. My laptop charger, flat surface to take my exam on, my eyeglasses, a few snacks, scrap paper, and a separate piece of paper to write down the professor's password to the remote exam, and the recovery code should your laptop lose power or stop working somehow. Whether or not you have accommodations that allows you to take breaks, the software that you're taking the exam on will usually disallow access to the internet and or other programs. Additionally, the program will log the periods of time, a start time and end time, where you are idle. So on a separate piece of paper, log the times and reason why your computer was in idle mode. The registrar of your school may want to know that. Just some super quick points. Even if you're taking the exam remotely at home, make sure you have your full setup at least 1 hour before your exam is supposed to start. That includes having your laptop on, the ExamSoft program that you have all snacks, your beverages, extra scrap paper, your pens, your highlighters, all set up at least 1 hour before the exam. This way, should any problems arise, you can call whomever you need to call. Remember that not all issues are created equal. There may be a major issue and several minor issues in an issue spotting exam. Discuss the minor ones, but leave the bulk of your time for discussion of the major ones. Once the exam ends, let it disappear from your mind. If it doesn't leave your mind, that could hinder you from the next exam because you're still stressing over the past exam. Definitely do not talk about it with other people because you'll only second guess yourself if they included something that you didn't. And that other law student you're speaking with could be wrong. A special note in civil procedure. Don't use the question mark as an abbreviation for federal question, as that gets confusing for the reader. Instead, perhaps say federal question and then in parentheses put in the quotes the letters FQ or hereinafter FQ. Remember, all your hard work will be worth it. If you're viewing this on YouTube, there are more tips and materials on our free Thinkific course. All you need is a valid email address. Now, we at Networking for Law Students LLC do not sell emails to any other companies, and we will not bombard you with a bunch of emails. There's no credit card sign up. This course is totally free, so be sure to check us out on networkingforlawstudents.thinkific.com/collections. Don't forget to subscribe to our brand new YouTube channel, Networking for Law Students LLC. Visit our website at networkingforlawstudents.com, and we're also on Instagram at Networking for Law Students 1 and on Facebook, Networking for Law Students.